So that is why you'll find that beneficiaries have a right to even take you as a trustee to court if you are not administering the trust properly.
So my kids can take me to court?
They can.
Good morning, ladies and gents. Today is really a beautiful day. We are joined by Sis Pat and we'll be talking about property. And now it goes without saying, guys, before I even let Sis Pat introduce herself, it's very important that we do not invest alone. And what do I mean by saying that we do not invest alone? We consult experts. It's very important. Let me emphasize that. We need to consult experts. So the expert that we have today is Sis P. It's impossible to know us and not know Sis P. Yes, Sis P.
Hey, good afternoon, guys. Good afternoon, and thank you guys for having me today, and thank you for inviting me to join you today. And yes, as he has just mentioned, we are talking all things property.
Awesome, Sis P. Sis P, right, we recently hosted a property workshop in Midrand, and then we were talking about forms of ownership. Forms of ownership is very important, and I don't know, Sis P, according to you, before we even get to the question, but it's not really popular whereby someone will come to you, Sis P, and say that, how can this form of ownership affect me, whether in a good way or a bad way? People are not asking those questions, Sis P. Are you also experiencing the same?
I am actually, because people, I guess they decide on their own at home. That is, I just want to buy a property, and there hasn't been like a lot of questions of someone asking me, I want to buy a property, or I want to venture into property investing, but can I use my personal capacity? Can I use a trust? Can I use a company? Only if you attend these seminars where you get these kind of questions. But when someone comes, already the OTP is signed, and there's no one who's asking, okay, which way? Trust, company, personal capacity. So I guess people, they decide when we're at their homes, and they just sign the OTPs with that decision that I'm in the right track, I guess.
Okay. So, Sis P, the first question that I have for you, right, is that we talked about trusts, we talked about having your property under a business, and we also talked about having a property under your personal capacity. So when it comes to trust, this is one of the questions that we received. Is there a limit when it comes to the number of properties that I can have under my trust? Because some people will be like, I've got 6 trusts and maybe I've got 3. So just let us know when it comes to the limitations, the number of properties that I can have.
You know, I just want to write it down so that I don't forget. I think the most important thing, which is why I'm even writing it down here, is that a trust is a highly taxed entity. So I think people need to understand that. That is why, again, when we go to these property seminars, we always emphasize on a team. So you need to have your own team. You need to have your own power team, where you know that you've got legal expert, tax expert, you know, all sorts, as everyone would prefer. So the reason behind all of this power team is that you need to understand how this whole structuring works. Because when we talk about property structuring, we're talking about shareholding, we're talking about being a beneficiary, we're talking about a whole lot of things. But the most important thing of all is that everyone doesn't want to pay more tax. So again, the most important thing is for you to know, okay, if I don't want to pay more tax, how can I structure my portfolio? So I think that's what is important, which is what I want to stress out today. So coming to your question again, is there a limitation? No, there is no limitation. It depends on a person. I can't say yes, I can't say no. It just depends on a person in a personal journey. How far are you in property investing? Because again, it depends on where the person is in his or her a property journey. Because if you have like 3 properties already, I will have a different conversation with someone who has 5 properties already. So there's no limitation, but again, it depends on the person. Again, we must always understand that if we're talking a property being transferred to a trust, we must know that you are removing a control. You're no longer going to have a direct control of that property, because remember, a trust is formed for the benefit of another person. So if you are transferring that property to the trust, you are merely saying, I am now taking off that control of the property. You are giving it to a trust. And then again, be aware that as trustees, you are administering a trust or a portfolio within a trust that doesn't belong to you. There might be disagreements, there might be disputes and all those kind of things. So be aware of those things. Again, you don't want to create a bigger portfolio in that trust where you don't have direct control. And then when there are disagreements, and then, you just don't know how to. Because that is why then this power team comes into play, so that then you can be able to consult before you obviously decide to move your properties into a trust. Hence, coming to the first thing I mentioned about a company where there are shareholders and now you don't want to trade using a trust. And then again, I get a question from someone asking, is it wise to use a trust to trade or use a company? It also depends. But what we're always encouraging is do not trade using a trust, rather have a trust owning shares in a company and trade using a company. Mm-hmm. But then again, doing so, you need to consult so that you can understand how that structure works.
Suspect, when you were saying that when we get a trust, we are removing control from us. Now, the controversial part is that, yes, we're removing control. However, at the same time, we say that we want to protect this asset, right? So in us protecting this asset, what then happens is that we get beneficiaries. And then we also decide in terms of the shareholding, how we distribute that. So now my question is that a trust purpose, we are saying that we are removing control from ourselves and we still want to protect this asset. But now how vulnerable is the property from the shareholders and beneficiaries now?
I think again, the most important thing when you want to start with your property journey, coming to your very first question when you were talking about forms of ownership. Because if you were to transfer your property to a trust, one, are you opening a trust as a couple where you and your husband are going to be trustees, appointing an independent trustee? And then again, is it going to be a family trust? Is it going to be a property trust? So those kind of questions are the questions that you need to know upfront before you start thinking about registering a trust. And then again, when we talk about losing control, it's because a trust is taken as a contract between the trustees and the beneficiaries. So whatever is registered in the trust, it means it's not registered for you to have control. It's registered for you to have the beneficiary, because it's registered for the beneficiary's sake. So meaning as a trustee, you are administering a property that doesn't belong to you. It belongs to the beneficiaries. So that is why you'll find that beneficiaries have a right to even take you as a trustee to court if you are not administering the trust properly.
So my kids can take me to court?
They can.
I remember me hearing about this the first time. It was crazy, because now you are thinking at it from a perspective that I started this, right? And I'm the one that built this whole trust. But now these kids are coming back and telling me that I'm taking you to court. I can't have this. I think that's a bit unfair. What do you think? I know that.
I think the most important thing is just to understand how it works. Because remember, as trustees, you are given a duty. You are given a duty whereby you have to look after a certain asset on behalf of someone. So that is why when we go to these seminars, we talk about a discretionary trust. So a discretionary trust, it says that you are having, you as a trustee, you're having this right whereby you are able to distribute within your beneficiaries. So meaning that, because remember, you can have a discretionary trust or you can have a vesting trust. So a discretionary trust.
Please bear with us. You said vesting trust, and
so
then
I'm taking discretionary trust, and I'm taking vesting trust. So what does this mean? When you have a vesting trust, it means that the assets within the trust, they invest in the beneficiaries. Okay. So beneficiaries now have control.
Okay.
When you have discretionary, it means that the assets vest in the trustees. then it means that the trustees have control in terms of distribution. So they will decide how they want each beneficiary to benefit within the trust. Yes. So in the vesting trust, then you are giving ownership already to your beneficiaries. Whereas in a discretionary, you still have control in terms of how you want them to benefit. Because beneficiaries, we have capital and we have capital beneficiaries.
Yeah.
And then we have what's the other one? I forgot now.
Okay.
The English word ran away.
Okay.
Yeah, we have capital beneficiaries, and then we have the other. I don't remember the name now.
Okay.
So with that, it means that you can decide with the income. That is the word I'm looking for. We have capital and income beneficiaries.
Okay.
So it means that you can decide how you want your beneficiaries as a trustee to benefit. So you can choose if I want to give 50% or 60% to Ulebo, and I want to give you 40%, I can decide how to do that. So that is why, again, what I'm stressing is get an understanding. Don't just think that because I listened Suspect on YouTube talking about this, then I'm good to go. Or rather sit down, because remember, each person's journey is unique. It's not the same. So you need to understand where you are in your journey so that you can know how does this fit in your journey.
Okay. Yes, but we're learning, guys. We're learning. I don't want to check on Lebo's notes. Go to how did he spell discretionary trust. We'll forgive him for now. There's also another question that came through, right? Now that we have an understanding of trust, one is asking themselves, I have a will. Now, with this will that I have, is there a difference between a will and a trust? Can I just sit on my will, or should I be converting? Can you please just answer that in terms of what is the key differences between a will and a trust?
And a trust. I think firstly, let's talk about the definition, because when you have a trust is a structure into which assets, I would say assets, not necessarily to say property, is transferred and is administered then by trustees on behalf of beneficiaries, right? In accordance with the trust deed. So the trust deed is like a constitution of how you need to administer the trust, right? So when you do that, one, because remember we always preach estate planning. So the main aim here is continuity. So meaning you are doing all of this structure because you want continuity. Even if you are not there, everything must continue as if you're still alive, right?
Okay.
Whereas when we talk about a will is when you say, I want this to be done this way when I die. So meaning that you are only documenting how things must be set out when it happens that on that day you are no more.
Okay.
So it means there's no continuity. It ends when you die. If I can put it in simple ways, is that in a will it ends when you die, because you have to do everything according to how the testator, the person who did the will, has directed you. Whereas in a trust, you are saying, I want everything to continue even after my death. I want everything to still continue. That is why you have trustees. And if you have a family trust, then you have to have an independent trustee. That person is independent of everything that is happening there. That person is able then to advise everyone involved in the trust as to how things should be done, and also to deal with compliance. So it's important again that you must know it goes back to each person.
Okay.
Because again, one would think, can I have a trust and not have a will? Can I have a will and not have a trust? Can I have both? So if you were to ask me, I would say have both.
Okay.
The reason why I'm saying, in my own personal opinion, it's better to have both is because in a trust you would structure your things in a trust, right? Because you structure your stuff there because you want everything to continue. But then you will have maybe your cars, and then you will have your other, like let's say your furniture, that your expensive furniture, whatever other assets that you have. Those assets, they are not in the trust. So you need to deal with them in a will, and you need to give them to whoever that you would want them to benefit. So you need on your will then to appoint those who would want to appoint. Remember again, in your trust, you don't have an executor appointed in a trust. Executor is appointed in a will. So that is why I'm saying, in my opinion, I would say have both. But then again, it's important for us to understand that it's a person's journey. So I would advise you differently from
will.
Yes,
Yeah.
I wouldn't advise you the same way.